Thank you, Demetriadis. Now for the Republic of Cyprus, I call Mr. Von Loo, please. Or Mr. Saini first.
Subject to your permission to speak first. Mr. President, I propose to address two issues in my submissions to the Court. First, the issue of ethnic discrimination in Article 159 of the TRNC Constitution, and secondly, the ineffectiveness of the 2005 law. So if I may first turn to the issue of ethnic discrimination. This is a fundamental matter which was unfortunately ignored in the Zanaidis Orestis case and is also ignored by Turkey in its written submissions and by Sir Michael in his oral submissions this morning. Given the importance that Turkey places upon the Zanaidis Orestis decision, this is a matter which the Grand Chamber must grapple with at this stage. We submit that the 2005 law must not be recognised or be given any effect because it is a means of giving legitimacy to the mass expropriation of property in the north on the basis of Greek ethnic origin of the owners of the property. What Turkey is doing with the 2005 law is trying to purchase the right to discriminate on ethnic grounds by requiring Greek Cypriots to accept the loss of their property and by accepting small sums in compensation in return. Now, we respectfully say that the Court should be very careful here, because Turkey is trying to make this Court complicit in that act of discrimination by asking it to endorse the 2005 law. The Court should not accept this. As the Court is well aware, discrimination on ethnic grounds is not only contrary to Article 14 of the Convention, but also violates binding rules of customary international law. And this Court itself has repeatedly emphasised that discrimination on grounds of ethnicity or national origin is a particularly invidious form of discrimination. Now, I should just explain how this discrimination arises. As this Court is aware, the basis and origin of the 2005 law is Article 159 of the TRNC Constitution. That is the provision that this Court in Louisidou and in the Fourth Interstate case said was completely invalid. But that remains the basis of the 2005 law. The materials that you have before you, Mr. President, demonstrate that it is only those who are Greek or of Greek Cypriot origin whose property has been taken under Article 159. Now, there can't be any dispute about this because it emerges from Turkey's own documents. And I will take three brief examples. First of all, if one looks at the 2005 law itself and recital 3 of that law, it says that the law is to be applied having regard to the principle of bizonality. That is a principle which Turkey, unlike Cyprus, interprets as amounting to ethnic cleansing through a forcible taking of Greek property in the north. And bizonality in Turkish eyes is a concept which has no other meaning than a division between those of Greek and those of Turkish origin. The second thing I'd ask the Court to look at, and I'm sure the Court will look at this judgment in detail when it enters upon its deliberations, the second matter is the Constitutional Court's judgment, which Mr. Wood referred to this morning. Now, that repeatedly says that the 2005 law is concerned with not properties belonging to all persons, but to Greeks. Pages 31 to 33 of that judgment. To take another example, at page 32, the Court explains, and I quote again, "The aim of the law is to regulate the movable and immovable properties of Greeks who had rights to them before 1974. To the same effect, see page 43. At page 50, the Constitutional Court of the TRNC says that the limitations in the law of return on property are aimed at, quote, not spoiling the two-part system. Again, a reference to bizonality. The third item I'd ask the Court to look at, by way of Turkey's own documents, is Turkey's memorial at paragraph 48, where Turkey itself says that the 2005 law is aimed at providing a complete system of redress for, I quote, Greek Cypriot property owners. To the same effect, paragraph 39. So, as we explained in our memorial, Mr. President, and as is now confirmed by Turkey and by the TRNC's own constitutional court, it was only the property of Greek Cypriots or Greeks which was identified as being capable of abandonment for the purposes of Article 159 of the Constitution, and it is only now that property which is the subject of the 2005 law. So if I was a Frenchman by any chance who happened to have lost property or potentially could have lost property in 1974, it is not taken away by Article 159. I kept it. It's only Greeks or those of Greek Cypriot origin who lost their property. Now, this is a vital fact which was overlooked in the Zenaides Orestis case, and it's also a vital fact given that we are now in a new pilot procedure in these cases. The purpose of the pilot judgment process is, using the words of the Grand Chamber in Bronialski, and I quote, to facilitate the most speedy and effective resolution of a dysfunction in the national legal order by ensuring that states remedy the systemic defect underlying the court's finding of a violation. So if this is to be a pilot judgment case, the role of the Grand Chamber here and now is to identify and declare that systemic dysfunction. What was it? The dysfunction is the ethnically motivated expropriation of Greek Cypriot or Greek-owned properties. And that continues to this very day, and it's a fact which this court, we respectfully submit, cannot ignore. Does the 2005 law deal with that? It simply does not. It doesn't put an end to discrimination, it does the opposite. What it seeks to do is it seeks to legitimise, and to make the court complicit in this, legitimise the ethnic cleansing and appropriation of properties by requiring those discriminated against to take compensation and then to make restitution the exception and not the rule. So we submit that requiring Greek Cypriots to seek a remedy before the Commission, while Article 159 of the Constitution remains in force, with its aim of forcible expropriation on ethnic grounds, is simply wrong in principle. Now, to give an example to the court, if France decided one day to expel ethnic Germans from Alsace-Lorraine, Romania decided to expel Hungarians, or Slovakia decided to expel the Roma, each to receive some desired ethnic dominance or balance, the court would clearly find violations of multiple articles of the Convention, and those breaches would continue unless and until the implementing measures were eliminated. Why should Turkey's expulsion and refusal of return of ethnic Greeks to the cleansed occupied area be treated any differently?